If I don't do nothing else, I'm gonna talk that law. Let's talk about it. They done held Trump in contempt. In contempt of the court. Golly. What's going on over there in New York holding that man in criminal contempt? So today I want to break down the contempt order that was signed by the judge. Somebody said, you ain't got to break it down. Just tell us if you're going to jail and for how long. Well, we're going to talk about all that. We're going to talk about it. But before we do, like, comment, subscribe. Y'all will put in the comments, or you may say to yourself, well, he sure talked that law today, but won't even hit the like button on the way out. I'll be doing that too sometimes. Sometimes I'll be forgetting. So that's why I say, do it in the beginning. You ain't got to worry about it. And this really helps with the YouTube algorithm, especially since I've been out for like a week. I just got off a plane. I flew down to the East Coast, my best friend's wedding, and I halfway lost my voice. So if I sound a little hoarse today, that's why. And then on top of that, I was getting ready to start this video. Something got in my eye and my eye started turning red. You can't make this up. So then I had to rinse my eye out and let the redness go down. I said, I'm not going to be able to make a video. And then as soon as I get ready to hit the live button, I get a knock at the door from my neighbor. He's like, hey, did DoorDash leave my order over there? Is your order outside? If it's not outside, then they didn't leave it. And I'm glad I didn't hit that live button because I was just about to hit the button. And here he come looking for his order. They probably took that order home with them. But we're going to talk about Trump. But before we talk about Trump, y'all heard about Fonnie. Fonnie. They said they caught her in Florida running from a reporter. And they say she was with a man. And they say he wasn't her husband. Oh my goodness. My voice is really hoarse. Y'all probably can't tell, but I can feel it. I had so much fun at the wedding. I had to double back my tie. One of my ties, and I ain't gonna push it all the way up today because I looked at that order. I took a glance at it. It's like 8 pages. I can't read all that, and my neck all choked up. But finally, what you doing running in Florida from the reporter's questions? I thought you liked the camera. You don't like it no more? Now, I haven't been on in a while, so YouTube might punish me. Now I got to work my way back up. They might not even recommend a video. But guess what? I'm still going to talk that law. And normally, I go live later in the day. But I had time today. I said, why not go live early? The words say early will I seek thee. So let's talk about the contempt order. And we're going to try to share this screen so we can get the reality of what the judge told Trump today in his contempt order. So let's see if we can add it, excuse me, to the screen. Let's see if this is going to work. All right. Oh, there we go. And it looks like it's readable as well. It's big enough. So let's go through it, and I'm going to skip read because this is a lot. Skip reading, just basically we're getting the substance, we're getting the meat. You don't need every single word to get the meat of what they're saying. So let's see if we can break it down. The Supreme Court of the state of New York. And I believe I explained this earlier. In New York, they had their stuff backwards. It's not the Supreme Court like we normally think. The Supreme Court, that's like the biggest court, the highest court in the land, the court of last resort. This is the trial court. So it's the lower level court. And it's the people of the state of New York against Donald J. Trump. Decision in order, people's motion for contempt. And it was signed by Judge Mershon. Let's see what the background says. Defendant is charged with 34 counts of falsifying business records in the first degree. The charges arise from allegations that the defendant, Trump, attempted to conceal an illegal scheme to influence the 2016 presidential election. Specifically, the prosecutors of New York, they claim that Trump directed an attorney who worked for his company to pay $130,000 to an adult film actress shortly before the election to prevent her from publicizing an alleged sexual encounter with the defendant. First of all, this has nothing to do with the actual contempt order. So the judge doing the most. I'm guessing he thinks that this will be appealed, so he's trying to cover his bases, but it is wild that it's in here. Oh my goodness. Not an alleged sexual encounter. It is further alleged the defendant reimbursed the attorney for the payments through a series of checks and caused business records associated with the repayments to be falsified to conceal his criminal conduct. Trial on this matter started on April the 15th, 2024. So before I read the next paragraph, let's stop right there because it was something that I seen. We're going to go right here. Specifically, the people. Come on back. The people claim that defendant directed an attorney. Now, I don't know if some of y'all listened to the tape, but it was clear from, I think they call it the Access Hollywood tape. It was clear to me from that tape that Michael Cohen, Trump's attorney, was doing the directing, if you will, not Trump. He was telling Trump what to do. He was telling Trump on it, and you can listen to the tape. And if I can find it on here, I'll play it myself. Trump really just lost. And you can hear Michael, his former attorney, telling him what to do. Trump just wants to pay this woman, make this go away. Trump not even admitting that he slept with the woman. He just wanted to go away. I mean, he's married. He has a wife. He just don't want no parts of the story. And it's alleged that this affair with this lady, Stormy Daniels, happened while she was pregnant. And of course, they say Stormy Daniels, in the words of 50 Cent, is a sex worker. You little sex worker. That's what 50 Cent say. And Trump don't want no smoke around his wife with this story. You're like, hey, just pay her. Even if Trump's saying it's a lie, just make it go away. So he attempted to pay her. And Trump wanted to pay her in cash. He went to the school of Fannie Willis. He went to her school. So he know how to hide that money good. He said, hey, we're going to pay it in cash. Now, he said, no, why do we have to pay her, in a check? And why do we have to create a fake company? And it was some word that Michael used. What word did he use? I think financing. And Trump was like, what are you talking about financing? It's 130,000. Matter of fact, let me see if I can play that tape really quickly, just so y'all can see what I'm talking about. Because some just ain't right. Let's see. I'm gonna find that tape. Okay, here we go. This might be one. Let's try this one. Oh yeah, this is the one. This is the one I played earlier.
For the first time, we're hearing a recording of President Trump and his personal lawyer, Michael Cohen. Now, on this 2016 tape, which was secretly made by Cohen, the two appear to discuss paying off a former Playboy model who claimed to have had an affair with Mr. Trump and debate how it should be done. A portion of that conversation was released by Cohen's attorney, Lanny Davis, to CNN on Tuesday night.
I need to open up a company for the transfer of all of that info regarding our friend David, so that I'm going to do that right away. I've actually come up and I've spoken to Alan Weisselberg about how to set the whole thing up with funding. Yes. And it's all the stuff, because you never know where that company, you never know what he's going to be. Correct. So I'm all over that. And I spoke to Alan about it when it comes time for the financing, which will be.
Listen, what financing?
We'll have to pay you. So no. I got no.
And the tape cuts off there. There are already conflicting interpretations of what exactly the two men say there. The president's lawyer, Rudy Giuliani, told CBS News in a statement, the transcript that we provided CNN accurately reflects the taped conversation. We'll have more on Wednesday about those competing understandings of what was said. CBS News has reached out to Michael Cohen's attorney, Lanny Davis. We hope to have more from him as well on Wednesday, right here on CBSN.
So y'all heard that, right? Did y'all hear that? Michael Cohen, the lawyer. All right, I had to stop that extra sound. I don't know if y'all can hear that or not. But Michael Cohen, the lawyer, he was the one directing all of this. Trump said, hey, I just want to pay this woman, make it go away. But Michael's like, don't pay her in cash. The simple and easy thing to do is let's set up some fake companies. Let's create some fake checks. Let me use my own personal money. This is Michael talking. I'm going to use my own personal money to pay her. And then Trump, you write me checks back. And you can hear Trump like, why are we doing it like this? What financing? Why? And another thing that gets me about his former attorney, Michael, is that he secretly recorded that conversation. And that makes me wonder, for what purpose? Why did you secretly record a conversation between you and your attorney, or you and your client, an attorney and a client, and this attorney-client privilege? Were you trying to blackmail him later, once he became president? Or, Michael, did you know what you were doing was wrong, so you decided to record it as insurance? Because I can't think of any good reason for you to And I'm not talking about a security camera in the attorney's office or anything like that. This was a secret recording that he had against his client, Trump. And of course, Trump doesn't know he's been recorded. He probably didn't think he was doing anything wrong. He was assured by his lawyer that we can do it like this. So, on the advice of his attorney, he went through with what the attorney told him to do, but now they're charging him. And that's my issue with the case. It's not that I'm taking up for Trump or I like Trump or don't like him. I'm looking at the facts and the law like I do when my own clients retain me as a 5-year Texas trial attorney. And I have a feeling, and someone commented, I think it was Carol. I have to go back and see, but someone commented that the lawyers that's on the jury, they may be liberal attorneys, so they may not, swing towards Trump's vote. And that may be true. I mean, it is New York after all. But they still have the knowledge and the skills to analyze whether the facts and the law is enough to prove Trump guilty. As attorneys, they're trained to know elements. You take a fact pattern, you take elements, and you push them together. Do they fit? I don't care what law school you went to. You have to have fact patterns, write case briefs. I mean, I don't care what law school, what side of the country, you wrote some case briefs. There's no way around it. And then writing those case briefs over and over again, you're taking facts, you're taking law, and you put them together and you see, do they match? And they don't match, then you cannot find somebody not guilty. But some of the people in New York may not like Trump, so they may say, you know what? Whether you guilty or not guilty, we're going to find you guilty. And in that case, if you have a few people that don't agree, then it'll be a hung jury. And from what my understanding, it's already been reported that when prosecutors was presenting a piece of evidence, one of the attorneys had a peculiar look on his face like he didn't believe what they were saying. And this is coming from some of the witnesses in the courtroom. So who knows? We're going to see. But let's get back to the motion, to the order, the motion for contempt order. I just wanted to take y'all to Michael Cohen to show y'all how this all started and to where we're at now. So I'm going to see if I can get back over here to share the screen. All right. All right. So I think okay, let's get back. I think I stopped at April 15, 2024. So let's start the second paragraph. On February 22nd, 2024, the prosecutors filed a motion to restrict statements of Trump. The court granted the people's motion and issued an order. On March 28th, the people filed a pre-motion letter seeking clarification or confirmation of the March 26th order. March 26th order as to whether it prescribes extrajudicial speech against family members of the court, the district attorney, and all other individuals mentioned in the order. So what they said was, we want clarification. We know you wrote this order, but what is it saying? So April 1st, the court issued another order expanding what was already contained in the March 26th order. And then Trump, he tried to fight it. He went to the appeals court, which is the court above the trial court. and it was denied April 9, 2024. So basically, not only did the prosecutors, the people, want clarification, they asked for the order to be expanded to include more people. And I'm gonna take this thing, I'm gonna try to scroll up slow. Y'all know how this computer be doing. It has a mind of its own. On April 15th, the people moved by order to show cause for this court to find Trump in criminal contempt for allegedly willfully violating the expanded order on three separate occasions. Defendant was served with the signed order to show cause the same day in court. On April 18th, the people again moved by order to show cause for this court to find Trump in criminal contempt. So this has nothing to do with the trial. This is like a sideshow. The prosecutors are saying, hey, he's violating your order. He's talking about Michael Cohen. He's talking about Stormy Daniels. And the court told him not to do it. And they're basically saying, hey, court, he's doing it anyway. What you going to do about it? And the court, being the court, can normally throw someone in jail if they don't comply with a court order. But Trump is not your normal defendant. It's hard to put him in jail. He's a former president, so he has Secret Service. Not only that, he's a potential future president, the Republican nominee. So he has extra Secret Service protection. And holding him in a local county jail is just not plausible. So they saying, Judge, what you going to do about it? You only got two options. You can fine him or you can throw him in jail. So the judge had a hearing, and it was conducted on April 23rd, 2024, which was what, about a week ago? The people, the prosecutors, they wanted $1,000 fine for each alleged violation pursuant to Judiciary Law 751. They also asked the court to remove 8 offending posts from his Truth Social accounts, Trump's Truth Social account, and 2 offending posts from his campaign website. Golly, y'all following this man. Y'all stalking. Why y'all all on this man Truth Social and on his campaign website? Then they wanted him to be warned that if you keep it up, it won't be tolerated. And remind him that incarceration, jail, is still an option. Jail ain't no option, and y'all know it. Stop it. At least not right now, because there's no way to do it where it can be safe. I mean, obviously they've been having incidents outside of the courthouse, so we know that it ain't like it's a secure area. So anybody that's not in their right mind could try anything. So it's just not plausible right now for that to happen, even though the judge is threatening to do that in his order. Come on, really? Okay, here we go. Maybe it's me. With these iPads, sometimes you got to use iPads. What is it, AirPad? You scroll with one finger, then you scroll with 2 fingers. It won't move, or it might go back up to the top. Okay, let's see. It's ordered that the court's order March 26 is amended, that Trump is directed to refrain from making or directing others to make public statements about known or reasonably foreseeable witnesses concerning their potential participation in the investigation or in this criminal proceeding. Okay, so that's pretty basic. If you know a witness is going to be in this trial, don't talk about them. But from my understanding, the prosecutors don't even want to turn over their witness list. So how I'm supposed to know if I'm Trump, if I'm violating, a potential witness, if they haven't made their witness list available? B, making or directing others to make public statements about counsel in the case other than the district attorney. So you can talk about the boss. You can talk about Alvinbragg, the head prosecutor, but you can't talk about any other district attorney that works for him. Okay, strange. You can't talk about members of the court staff and the district attorney staff. So I guess you could talk about the judge, but you can't talk about none of the judge's court staff. They even added number 3. You can't talk about Trump, can't talk about the family members of the lawyers, the staff members, family members of the court, or family members of the district attorney. So supposedly the judge's daughter has some involvement with the Democrat Party. And obviously Trump is going to say that it's coordinated. The judge should recuse himself. His daughter is directly involved with the Democratic Party. So the judge has in his order, quit talking about my daughter, or you're going to have to see me. Don't play with my kid now. So now Trump is not allowed to talk about any family members if those statements are made with the intent to materially interfere with or to cause others to materially interfere with counsel or staff's work in the criminal case, or with the knowledge that such interference is likely to result. So Trump is saying, you blocking my First Amendment rights by saying I can't talk about these people. He's also been ordered to, letter C, you can't make or direct others to make public statements about any prospective juror or any juror in this criminal proceeding. Now that one kind of makes sense, and it makes sense even without a court order. You don't want to be talking about a member of the jury. I mean, it doesn't make sense, right? The people that's deciding your fate, literally, they will be the last people that you would want to talk about. Because obviously, if someone is talking about you, you're likely not going to vote in their favor. I mean, that's human nature 101. So that one's a given. But I guess that one was before. Look at this computer. I guess that one was before the jury was seated, because it also said prospective juror. I'm gonna see if there's a different way I can do this next time. I might have to download it, because this is insane. So they have findings of facts. So basically, the prosecutors, they created a list of all the times he violated the court's order, and they put them together as exhibits. And you can see most of this stuff is straight from his Truth Social account. Exhibit 1, a post on Truth Social. Exhibit 2, a post on Truth Social. Exhibit 3, 4, 5, 7, 9, and 10. And it looks like exhibits 6 and 8 came from his website. So they're looking for anything and everything to get Trump held in contempt. Is it going to help with anything? I doubt it. Now, if the thing is, if Trump was threatening the witnesses, that's one thing. Like, hey, if you come to court and testify against me, such and such will happen to you. Okay, that is definitely not allowed. But that's not what Trump is doing. All he's saying is, excuse me, my voice barely hanging on. All he's saying is, he's not threatening Michael or Stormy. He just write on Truth Social that they know damn good. That's all he's saying, that they know damn good. He ain't telling us nothing that some of us don't already know, especially with that sneaky ex-lawyer of his recording him without his permission, with no valid purpose or reason of doing so. So, of course, Trump didn't pardon him. Why would he pardon somebody that was sneaking and conspiring against him behind his back, making tapes to be used later against him? And now he's coming to court, obviously going to be testifying against him. So Trump's saying they know them good. And I'm paraphrasing. I think his words were they sleaze bags or sleaze ball, whatever he said. And he said he gonna keep saying it. He gonna keep saying it. Oh my goodness. And let's be clear, Michael, they doing podcasts, book deals. It's not like they borrow. Him talking about them is actually helping them. There's more stuff that they can put in their book. There's more stuff that they can write about him. So it's not like that they're scared of Trump. They're not scared of him. They like keep talking about us. And the judge is blindly falling for it and making Trump not talk about them, but they can talk about him. So basically, they're really goading him into talking about him. They're basically saying, we're going to talk about you and you can't do nothing about it. And if you talk about us bad, we're going to tell the prosecutors to tell the judge to get you in trouble. This sounds like some kid stuff, don't it? And some of the stuff were reposts. Trump didn't actually write it. He just shared something that somebody else wrote. And obviously the court is saying you can't really do that because you can tell somebody to write something, bad, and then all you have to do is share it. So the judge is like, you can't be reposting. And also it shows defendant does not dispute that he either posted or reposted all 10 posts in question. He said, I did it. What you gonna do about it? Yeah, I'm talking about them. They talking about me. You not saying none of them. Why you saying something to me, Marshawn? And Trump is even arguing that reposting it does not violate the order. You see the last sentence, because the words are not his own, but those of someone else. And he believed that reposting was permissible because the people in the court did not move to enforce the expanded order after the first repost, and that he did not willfully violate the expanded order because the post constitute protected political speech made in response to attacks by Michael Cohen and Stormy Daniels. And then the judge pretty much just breaks down his authority under the law. What does the law say? And the law gives court, without reading all of this, the law gives courts inherent authority to control their courtroom. Because if they had no way to control their courtroom, it'd be out of order. Imagine if someone wanted to do what they wanted to do in court and there was nothing the judge can do about it. Then you would have no order or control of your own court. So the way you do that is punishment by fine and punishment by incarceration, jail. And in some states and counties, they get even more creative. But I believe in New York, they only have those two methods: money or your freedom. Even in a YSL case, that's the case going on in Georgia. Another case that Fonnie Willis brought, that judge, he had, for contempt orders in his court, he had lawyers buying lunch. He had lawyers writing essays. He had a potential jury member writing an essay. Yeah, he had a lot going on. He was doing all that, doing the most, the YSL judge. And now his courtroom has become a complete circus. He can't control his court. They're running all over him. Don't know the law. Heavily biased. Taking up for the prosecutors every chance he gets. And now he's getting tired of it. I think it's day 69, day 70 of a trial. He's tired. He wants it to be over. He's even threatening the attorneys that they're going to start having court on Saturdays. Well, Judge, if it's for the betterment of my client, we can have court twice on Saturdays. Because threatening me with court on a Saturday so I can hurry up and speed up the process is a violation of an attorney's oath. So I agree with the court on Saturdays, but he hasn't enforced it yet because I think he don't want to be there on Saturdays himself. But back to this judge, all he can do is a fine and money. And I believe the fine is actually capped at $1,000. So he can't even do more than that. Let me see if I can keep scrolling. The decision. This court rejects defendant's arguments and finds that the prosecutors have established the elements of criminal contempt beyond a reasonable doubt as to exhibits 2 through 10. So it seems as if the judge 2 through 10, what is that, 9? So it seems like the judge only is finding him in contempt for violating 9 of the prosecutor's original 10 violations. And I believe since this happened, more violations they filed for, saying he's violated it several more times. And if y'all look at this footnote number 4, Trump's attorney basically said Trump only responded on Truth Social because he was attacked first. And then the court said at the hearing, the court gave defense counsel numerous opportunities to cite actual instances where the defendant's posts were made in response to perceived attacks by protected witnesses. Aside from referencing a tweet in their response to papers relating to Exhibit 1, counsel was unable to direct the court's attention to any other specific attacks by the protected witnesses, which immediately preceded defendant's post. Defendant offered no exhibits at the hearing. So what the judge said, you telling me, Trump's attorneys, that he's responding when he's attacked. Where are those attacks? And Trump's attorney couldn't give him a clear answer. And when he couldn't give him a clear answer, the judge told Trump's attorney, you're losing all credibility with this court. Basically, he's saying, hey, everything you say a lie, and I'm not going to believe you the rest of the trial. Because you can't point to specific instances where Trump was responding to an attack. And that's the thing. When you make an argument, you better make sure you have your facts straight. You better make sure you have your ducks in a row. Because it's easy for the judge to ask that question. Like, okay, if he's being attacked, where are those attacks? And the judge basically does his analysis saying some of the exhibits, violated the order. But he did say the issue of reposting appears to be a question of first impression. Basically, reposting, a case of first impression, is basically, it's never happened before. It's never been argued in court before, so it's brand new. It's reposting what someone else say, the same thing as you saying it. Do you agree with that post when you share someone else's post? What if you sharing it to show the world, like, look what this person is saying? Can you believe they said that? I'm gonna share their post. Does that mean that I adopt everything that post said. Doesn't mean that I'm signing on 100% to everything that post said because I shared it. And that's what the judge means. This is a case of first impression that has to be analyzed thoroughly by the appellate courts. But the court said, as of right now, since I'm lacking legal authority, we have no other cases that's similar to this one. He said he's going to rely on common sense. Oh, my goodness. Not common sense, Judge. He said forget legal analysis. We're going to use common sense. And, oh, come on, really? It's only 8 pages, so, and I'm going to really figure out why does it always do that. Okay, here we go. Both the Truth Social account and the official campaign website exclusively represent the opinions and views of the defendant, and neither is an open forum for others to post their own content. I don't agree with that because, like I just said, just because I share something, that don't mean that it exclusively represents my opinions and views. And they said that the judge went on to write that Trump, he posted it and took the necessary steps to publish the post on Truth Social and on his campaign website. Get off that man's website. Why are you on his website? And they said that he did that because Trump posted it because he wanted to maximize viewership and communicate his stamp of approval. Indeed, defendant has boasted about the reach of his Truth Social platform when describing its value. More importantly, Truth Social is the primary way, I guess this is Trump words, it's the primary way I get the word out. And for better or worse, people want to hear what I have to say. Perhaps, according to experts, more than anyone in the world. On Truth Social, I have 7 million followers. When I put out a statement, it is spread all over the place, fast and furious. Everybody seems to get whatever I have to say quickly. If it didn't work or properly get the word out, I wouldn't use it, but it does work, and it worked really well. I don't know if this is appropriate for the judge to quote because from my understanding, Trump has the interest in Truth Social. So, of course, he's going to hype it up for market value. He wants people to go to that platform, sign up, get revenue shares, make money. So that's a business statement. But that doesn't mean that he's saying that if he shares anything about Michael Cohen or Stormy Daniels, this same statement applies. That it's going to go all over the world. And that's the reason he's sharing it, for it to go all over the world. He's sharing it because it's his opinion of what he believes. What he believes is happening with this court case. If Michael Cohen's talking mess about him, Stormy Daniels talking mess about him, he's going to reply. The only thing is they need to keep the receipts. If Michael Cohen, and I believe Michael Cohen really amped it up for the now, I think he has a TikTok. And now he's really talking, which is strange. If you're going to be in a case, a witness in a case, you're not going to be talking about the case or watching the case, commenting about the case. So it's real strange that Michael is doing this. But now Trump might have ammunition now to say, hey, he's all on TikTok talking about me. Even though that's not going to help now, with this order, it'll help in the future. Like with this order, this happened in the past. You can't say Trump, you can't say Michael Cohen was talking about Trump today on, April 30th to have a valid reason of why you posted something on April 10th, April 15th, when Michael Cohen stuff hasn't happened yet. So you can't go backwards in time and say, hey, I did it on April 10th because I knew in the future, 20 days later, Michael Cohen was going to be on TikTok talking about me. So the TikTok will help in the future to allow Trump to continue to defend himself. And that's been my position all along. Either everybody gets a gag order or nobody gets a gag order. Because if I'm on trial fighting for my life or fighting to stay out of prison, I'm not going to let somebody spread false information about me in attempts to influence the jury through the media and I have to remain silent and not say anything, and could possibly be found guilty and sent to prison. So I get why Trump is doing what he's doing. Let's see if I can scroll up some more. Let me see if I can go down. That last sentence of that, thus there can be no doubt whatsoever, is the first paragraph that's showing. Thus there can be no doubt whatsoever that defendant's intent and purpose when reposting is to communicate to his audience that he endorses and adopts the posted statement as his own. And that's simply not true. Because I can share something and I don't have to endorse or adopt it. I can share it as to show my people, like, look what this person wrote. Or I could be sharing it for information purposes. That don't mean I agree with it. But I mean, it makes sense if you look at the full context. Because if it's something negative about Michael or Stormy and I'm reposting it, then obviously I'm reposting it for a reason. But that don't mean I endorse and adopt the whole statement as a whole. Let's see. It is counterintuitive and indeed absurd to read the expanded order to not prescribe statements that the defendant intentionally selected and published to maximize exposure. This is not to say that a repost will always be deemed a statement of the reposter, as context is directly relevant. However, here under the unique facts and circumstances of this case, the only credible finding is that the repost constitutes statements of the defendant. Well, the judge said it won't always be deemed a statement of Trump when he reposted. Well, who decides? What do you mean it's not going to always be deemed a statement of Trump? So that means you get to pick and choose. If Trump reposts one thing, he endorses it, but if he reposts something else, he doesn't endorse that. I mean, that's a slippery slope. And it's not a clear and crystal rule for Trump to follow. The last paragraph, turning on this page, turning next to the defendant's post in which he purports to quote Jesse, is it Waters? Let's see, Exhibit 10. This is not a repost, but rather the defendant's own words. Okay. So Trump used quotation marks. Well, that's different. Because if Mr. Waiters uttered a statement and Trump altered it and placed it in quotes, then he took out the part that he actually wanted to use. And this is the old one about the jury selection. It was a violation of when they was picking the jury. But that one didn't really apply because now the jury is seated. You don't have to worry about protecting prospective jurors because we already have our jury. So, like the judge said, requires no further analysis on that one because that one's a moot point. I mean, that's over with. All right, we're working our way to page 6. I'm going to stop it right there so it don't go to the top. The defendant Trump next argues that the statements contained in the exhibits were all made in response to political attacks, which he kind of don't have any proof of that. While the expanded order does permit defendant to respond to political attacks, merely characterizing every one of the defendant's postings as a response to a political attack does not make them so. So basically what the judge is saying, you can respond to political attacks because you're running for president. But what you cannot do is say every single thing that somebody says about you is a political attack just so you can respond. Because if that's the case, there's no use for a gag order because you would just say everything's a political attack and now you can talk about it, everybody back. So although defendant Trump did not produce any exhibits at the hearing, he did refer to 2 postings contained in his opposition papers. They include a post by Michael Cohen on April 9th, wherein he comments on those who support defendant for the presidency. in a second post by Michael Cohen on April 10th, referencing Michael's likelihood of receiving a pardon from Trump. So this one is a great area. Exhibit 1. I don't believe that Trump's posting of Exhibit 1 was used to violate a gag order, because he wasn't directly talking about anyone. He was just responding to what Michael Cohen had said about the other Michael. So the judge did not find Trump in criminal contempt of Exhibit number 1. So he just found him in criminal contempt for the remainder. Let's see what he says at the bottom. And I'm just paraphrasing just to save a lot of reading. Voice still halfway gone. Okay, so let's jump in the middle where it says, however, that cannot be said as to the remaining exhibits 2 through 9, which I just mentioned, which attack the credibility of arguably 2 of the more high-profile witnesses in this case. And that's a weird thing for a judge to say. Why are you calling witnesses high-profile? To you, as a neutral referee, as judge, they're just witnesses. They're not any more high-profile or less profile than any other witness, if through the eyes of a judge, put it like that. So for him to be calling these people high-profile is beyond me. But he goes on to say, to allow such attacks upon protected witnesses with blanket assertions that they are responses to political attacks would be an exception that swallowed the rule. The expanded order does not contain such an exception. And that's pretty much what I basically just said. Trump cannot say everything is a political attack, because if that's the case, then the whole rule would be throughout. The whole gag order would not have any teeth, because anytime someone says Trump violated the gag order, he can say, oh, it was a political attack, so I responded to it. But the judge does go on to say, at the same time, this court is keenly aware of and protective of defendant's First Amendment rights. Are you, Judge Mershon? Are you? Particularly given his candidacy for the office of President of the United States, it is critically important that the defendant's legitimate free speech rights not be curtailed, that he be able to fully campaign for the office which he seeks, and that he be able to respond and defend himself against political attacks. How are he going to campaign, Judge, when you got him in court Monday through Friday, while his political opponent, I mean, we're going to tell the truth, while his political opponent is out there on the campaign trail? Biden is on the campaign trail every single day, but Trump is stuck in the courthouse. So, Judge, don't tell me that you really, and I think we're on page 7 of 8. I know it keeps going back, but we're almost at the end. Don't tell me that you are concerned with his rights, his First Amendment rights, because y'all designed this trial, in my opinion, to happen right around this time. Y'all could have had this trial last year. Y'all could have moved it down later on, but y'all are having it right now. So let's see. So Trump should be able to defend himself against political attacks. For that reason, this court exercised discretion when it crafted the expanded order and delayed issuing it until the eve of trial. The order is narrowly tailored to prevent the risk of the fair administration of justice, and it clearly identifies limited ways in which the defendant's speech is restricted. It is of the utmost importance to this court that the expanded order not be used as a sword instead of a shield by potential witnesses. That's my point exactly. So the judge is saying that my gag order is not to be used as a sword for you to attack Trump, Michael, and Stormy. It's supposed to be used as a shield to block attacks. But what you can't do is talk about Trump. So he's kind of giving them a heads up, like, you can't talk about Trump and expect him not to respond and then come crying to the court saying, hey, he's talking about me, when you provoking him. And that's what the court is basically saying. You can't use this as a weapon, only as a shield. And then the court goes on to say consideration of such usage will be weighed by this court when rulings on the willfulness of any future claims of alleged violation of the expanded order, as well as when determining appropriate punishment, if any. So what the judge is saying, he's going to consider, Michael, if you're going to keep talking about Trump, he's going to consider that. Stormy Daniels, if you keep doing interviews, you're trying to write books, movie deals, he's going to consider this the next time the prosecutors come to him saying, he's violating the gag order, judge. He's violating the gag. The judge's going to say, hold up, wait a minute. What are they doing? Because obviously if they talking all this noise, Michael and Stormy or any other witness, if the young folks say turned up, then they don't need a gag order. They don't need to be protected because clearly they can protect themselves. So don't come crying to the court when Trump makes a statement about them. That's what the judge is saying. I'm just breaking it down. And he's letting them know. In fact, the court may very well consider the propriety of continuing the limitation on extrajudicial speech as it relates to certain individuals. He's talking directly right now to Stormy and Michael. He's saying he's going to consider the gag order for certain individuals since y'all running your mouth and y'all making my job hard. And the judge's job is hard because he has lost his only tool to make people act right, and that's jail. Because obviously it's going to be hard trying to lock Trump up, like I said earlier, the Secret Service. So the only thing they can do is fine him. But the thing is, the fine is capped at $1,000. And to Trump, $1,000 might be a penny or 10 cents to us as regular individuals. So the judge is basically saying, don't embarrass me because all I can do is fine him. Don't come crying to me when y'all are provoking him and all I can do is fine him $1,000. He's going to keep talking about y'all. He's going to keep willfully violating my order. And he's just going to pay the money. So the court doesn't want to be embarrassed. The court is saying like, hey, Trump, I can still put you in jail, just so you know. But at the same time, he's telling Michael and Stormy, I'm not going to do it if y'all are provoking him. Let's see. As this court observed in the expanded order, it remains this court's fundamental responsibility to protect the integrity of the criminal process and to control disruptive influences in the courtroom. Well, I guess in the courtroom, I guess outside the courtroom too. The underlying purpose, what's the purpose of this? Some people say unconstitutional gag order. What's the purpose? The underlying purpose of this restriction on extrajudicial statements is to protect the integrity of these proceedings by shielding those fearful of reprisal by the defendant Trump so that they can take a part in the proceedings without concerns. So the judge is saying, I'm going to protect y'all if y'all are fearful, if y'all scared that participating is going to bring harm to you. I'm going to shield you. But look at the next sentence, and I'm going to try to scroll up without it going away, where he really gets on them. He say, however, if a protected party turns that underlying purpose on his head and it becomes apparent that the protected party likely does not need to be protected by the explained order, he's going to cut it off. He said, I'm going to shield you if I have to. But if I find out that you're making a mockery of this process, you know how in the classroom, elementary class, when the teacher ain't looking, they may stick their tongue out at another student. And when the student responds out verbally, the teacher gets on the one that responded. Now I realize, like, hey, this person is sticking their tongue out, it's causing them. But now the teacher's like, I'm getting on the person that's responding verbally, but I know he's not responding out of thin air. So somebody's doing something to him. So I'm gonna tell y'all that if I get on him, I'm gonna get on y'all too. And that's what the judge is saying. If you don't need to be protected, get out of the court's way. We can take y'all out of this gag order. We can exclude y'all. We can say Trump cannot talk about the court staff, the prosecutor staff, any witnesses except Stormy Daniels and Michael Cohen or anybody else that's running their mouth that's still talking about him. The court is aware. Break it down. The court's aware that Trump has made through various motions he has filed during the pendency of this case, numerous references to the commentary of Michael Cohen and Stormy Daniels as indicated above, and will consider such in any future filings. Nonetheless, the court finds that it is not yet necessary to modify the terms of the expanded order to exclude any of the currently protected parties. So basically, he's giving them a warning. He's saying, I'm not going to exclude y'all right now, but I'm giving y'all a warning that I'm not going to modify the terms. But if y'all keep doing this, talking about Trump or having other people interview y'all so y'all can talk bad about Trump, right now as this trial is going on, I'm going to scratch your name off the list. And then if that happens, you know, Trump gonna really blast them. They think he's talking about them now. I think this is a nice version. This gag order get lifted, it's gonna be some mess. That's when it's gonna really hit the fan. So the court goes on to say the court finds defendant in criminal contempt for willfully disobeying a lawful mandate of this court in violation of Judiciary Law Section 753 on 9 separate occasions. Punishment. What is the punishment? Is Trump going to jail? If somebody want to know, is he going to jail? You read all that long talking, long order. Is he going to jail? No, he's not going to jail. The law in New York says criminal contempt is punishable by a fine not exceeding $1,000, by jail not exceeding 30 days, or both, in the discretion of the court for each violation of a court order. So for each violation, the maximum fine is $1,000 and 30 days in jail. Obviously, if the judge put Trump in jail with 30 times 9, 270 days, obviously that'd be a big problem that will likely not happen. Let's see what else he says that's relevant. Okay. The judge said the law does not vest this court with authority to craft an appropriate punishment when a $1,000 fine would not achieve its intended purpose. While $1,000 may suffice in most instances when it's regular people to protect the dignity of the court, to compel respect for its mandates and to punish the offender for disobeying a court order, it unfortunately will not achieve the desired result in those instances where the contemptor, I don't know if I'm pronouncing that right, contemptor can easily afford such a fine. And that word is basically a person that's held in contempt. And what they're saying is Trump is rich. $1,000 is nothing. And he's saying in those circumstances, it would be preferable if the court could impose a fine more commensurate with the wealth of the contemptor. Let's try that one. Contemptor. In some cases, that might be a $2,500 fine. In other cases, it might be a fine of $150. So it seems as if he's talking to the legislature. The judge can't change the law. So I guess he wrote this for the legislature, the people that write the laws. He's saying, hey, instead of maxing it out at $1,000, you might want to take a look at changing it to where judges can have discretion to fine people based on how much wealth they have, how much money they got, how much money they make. Change the law. But I don't think the law needs to be changed, because you won't have a defendant like Trump again for what, another 100, 200 years, who knows? Because most people can just go to jail. They don't have Secret Service protection. You can just put them in jail. They're not worried about the $1,000 fine. They're worried about going to jail. So I think the punishment right now is more than sufficient. But obviously it's not sufficient enough for Trump, because this is unique, as where he can't go to jail for an extended period of time because it's not secure. And I think that was it. Let me see. Was it one more page? If this computer play right. Okay. Oh, the last sentence. Because this court is not cloaked with such discretion, because this court cannot change the law to increase the fine, we still have jail. That's what the last sentence is saying in that first paragraph. Because this court is not cloaked with that discretion, it must therefore consider whether in some instances jail may be a necessary punishment. Therefore, defendant is warned. Trump, you warned that the court would not tolerate willful violations of his lawful orders, and that if necessary and appropriate under the circumstances, it will impose jail. And it's ordered that he pay a $1,000 fine for each of the non-violations by close of business on Friday, May 3rd. It is further ordered. Let's see if we can get the page. Can we get the page 8, computer? Good grief. That he remove 7 offending posts from Truth Social and 2 offending posts from his campaign website. And he got to remove those, or I guess he had to remove that that would have had to happen today. So that's pretty much the order of the court. That's the order of the court. So do I think it will stop Trump from blasting his former attorney and Stormy Daniels? Who knows? And who knows? He might push it as far as he can go. He might want to call the judge's bluff. Judge, you saying you can put me in jail? Put me in jail. That may actually give him what he wants. You put him in jail. Guess what? The trial is delayed. And from my understanding, some have argued that that's what Trump wants all along. He wants the trial delayed. Put him in jail with his Secret Service and a TV. That might even inspire more people to vote for him, because he's going to say, oh, they didn't lock me up. The judge working with Biden wanted me to win the election, so he has me sitting in jail as a political prisoner. Oh, my goodness. Oh, my goodness. Can y'all hear it now? Can y'all hear it? Can y'all hear? He has me sitting in jail as a political prisoner. Oh my goodness! But the judge is smart. The court doesn't want to be embarrassed. Basically, what I mean by that is the court doesn't want to say something and don't follow through with it, or don't have the ability to follow through with it. It's hard to say, hey, I'm gonna put you in jail, and then come to find out that's not realistic. It's not possible. And then someone above his head, I don't know, federal judge perhaps, saying, no, we're not going to let you do that. So now that threat, if that happens, the threat of jail is no longer on the table. So he's really going to go wild. So the judge he wants to keep that threat without actually having to go through on that. Because for some reason he doesn't go through with it, or if he does go through with it and it has the reverse effect of Trump getting campaign donations and all the craziness that comes with it, then the judge can no longer weaponize that threat. And that's what I was saying with the YSL judge. He keeps threatening that attorneys are going to have court on Saturdays, but he has yet to hold court on Saturday. And I think he doesn't really want to hold court on Saturday. He just want to use that as a threat. But once he actually has to go through with that, not only will it be miserable for the judge, because I'm convinced he doesn't want to be there on Saturdays, but once the attorneys find out, like, hey, Saturday is not so bad, maybe we can get this case over with quicker, it's no longer a punishment. I was in the store the other day, and this mom was giving her teenage daughter several warnings. Come over here, come over here, come over here. And she said, I'm not going to say it again. And I'm like, okay, all right. You say you're not going to say it again. And I'm minding my own business, getting my stuff that I needed. She said it 10 more times after that. So I said to myself, I thought you weren't going to say it again. So now your empty threat has embracing your daughter to not listen to you. Because what is the consequence if she doesn't come over? What is the consequence if you say you're not going to say something again and you end up saying it at least 10 more times with no consequence? So that's the same thing with the judge in the Trump's case. He's threatening jail, but he knows that it's likely not possible. And if he try to do it and it backfires, then that threat goes out the window. The trial is delayed. And if the trial, let's say Trump go to jail for 30 days, the jury may not want to hold on that long. They want to go on with their lives. So now you got to discharge the jury and you got to start all over again. So I'm thinking right now the judge's hands are tied, and he knows that that's what took him so long to write this order. There's nothing he can really do. And if somebody else has a creative way, they think he can punish Trump, but the law is clearly defined that either a fine or a incarceration, and obviously incarceration is not one of them. And did I take the comment off? So she wanted to know, I was late, is Trump going to jail? Not this time. He made it through. He made it through, but he was fined $1,000 each for 9 different violations. So he has to pay $9,000. And I think he had like a week to pay it. But the judge warned him, like, next time it might be jail. And he also gave a bail type of threat warning to Michael Cohen and Stormy Daniels. Like, if y'all keep talking about him, I'm not going to go after him. I'm going to go after y'all. I'm going to remove my gag order away from y'all two. And that way it'd be open season. Y'all say something about him, he say something about y'all. And obviously Trump been doing this a long time, and he has a bigger audience. He has a bigger social media platform. So if y'all want to go tit for tat, then the judge saying, hey, I'm going to move out the way. Don't come crying to me about Trump talking about y'all when y'all talking about him. We're not going to play that game. And on top of that, I have no way to really punish him because $1,000, he might tip the waitress more than that. So yeah, the judge is in a peculiar situation right now. But there is another violation, gag order violation, that was filed since these 9, but I don't think nothing's going to happen to them because this order just came out today. So Trump really didn't have enough notice about the new ones since this order came out today. So the judge, I don't think he's going to punish him because his warning came today with this order. So the judge might say, I'll fine him another, I think it's 4 more violations. I'll fine him another $4 more thousand. But going forward from today for anything new, then Trump will either deal with more consequences or pay another $1,000. So this is going to get interesting. But I just want to jump on here and break that down. And if there's any other topics concerning this whole circus, I haven't even broke down any of the opening statements or the witnesses, but I do plan on doing that. But supposedly Trump's lawyer is a new criminal defense attorney. That's similar to Nathan Wade and Bonnie Willis. Trump's lawyer was a career prosecutor, but they said in the past 10 years he might have had one case as a criminal defense attorney, and that wasn't even a hard case. So I'm trying to figure out what made him think he can come to the other side and just do a good job. Think about it like in sports. You might be a good quarterback, but when it's time to go on the other side of the ball and play defense, are you a good middle linebacker? Probably not. In baseball, you might be a good pitcher, but are you a good batter? Can you hit the home runs when we need you to? So just because Trump's lawyer was a prosecutor for years, a federal prosecutor, said he was real good at what he did, coming over to the defense side is a whole different ball game. And I believe that's why he struggled a lot with his opening statements. Every time he tried to get out his opening statements, the other side objected, because he didn't know how to present a case. He's always used to being on the other side, putting people in jail, but he had no idea how to play defense. And that's why his opening statements was choppy, and the judge kept sustaining the objections, which basically stopped Trump's lawyer from saying what he had to say. So I do plan on analyzing that and breaking that down. But I've been on here for about an hour already, so I'll let y'all go. I appreciate y'all tuning in. If y'all don't mind liking and subscribing and all that good stuff, so the YouTube algorithm could circulate this video. I've been out of town for a week for a wedding, for those that didn't know, on the East Coast, and I just flew back last night. And I done lost my voice, had a good time, my best friend. So I'm trying to get back in the groove. But YouTube will punish you. YouTube will punish you. Oh, thank you so much. YouTube will punish you if you take too long of a break off. So I said, man, let me get on here and do something. I got to say something. Because if not, they'll throw me on the back burner, and it'll be another minute before anybody sees these videos again. But thank y'all a lot. I do plan on hopping back on later in the week. Who knows? Maybe even be tomorrow. But let me give my disclaimer, so I don't get sued. This is not legal advice. This is commentary. I'm just talking that law. Man, so much I want to say. But I'll break it up so I can have more videos. But I'm a lawyer, but I'm not your lawyer. I'm just here to talk that law. See y'all on the next one.